if they did it.
My main to a large extent is a
There
lot
we
of
go.
the work that I do deals with senior citizens and their families. And it kind of can, as we'll talk about, it can kind of encompass a number of different areas. So I titled today's talk, what did I title? No, Plan for Your Tomorrow Today. And the reason, I like to talk about this is, I do my practice, I do work on the front side of things, which is helping people plan and get their documents and things like that in order. And then the other aspect of it sometimes is unfortunately when you have to go to court, when people have not kind of gotten their ducks in a row. And so while this is not necessarily fun stuff to talk about, I can just tell you, unfortunately, from experience that it's, that it's a lot better to kind of talk about something that might not be so happy-go-lucky as opposed to not taking care of things and then, God forbid, putting, yourself or your family into a really, unfortunate situation. So anyway, so I'll just kind of go ahead. I guess as you can kind of tell, I'm pretty informal, at least in these kind of contexts. So if anyone has a question, I guess I'm happy to entertain it. If it seems like it's something maybe better afterwards, I'll just let you know that. But anyway, so when we talk about, I'll jump around a little bit, but I'll try to loosely follow the handout. So when we talk about planning ahead, I kind of laid out what are the positives of doing that. And again, we'll go into the details, but when I talk about planning ahead, it's really kind of getting your documents in order for when the day may come when you're not really able to take care of your affairs. So, the importance of doing documents now while everyone is healthy and cognitively able to do that is a couple things. One, it allows you to kind of have a say as to how things might be for you if there comes a time when you're really an invalid, or if, God forbid, you come down with dementia or things like that. Because, like in my case, I have all the documents that we'll talk about today. So for instance, if God forbid something happened to me, I'm in a car accident or something like that, I've done all my documents so that my wife can just kind of step in, hopefully, and make those decisions for me. If I didn't have those documents in place, then, and again, as we'll talk about, then my wife wouldn't be able to, even though she's my wife, she wouldn't be able to go to the bank and access my account. Sounds crazy, but that's the way the law is. And she would have to go to court to get that authority, because I would no longer be able to give her that authority because I don't have the capacity to do these documents. So by me doing them now, I'm kind of controlling who I want to have making decisions for me in the future. So that could be with regards to health decisions. Sometimes people have a number of children and, they might need to appoint one of them to make decisions for themselves, for them if they can't speak to the hospital or they can't speak to the doctors. There might be one child who you think would just be better suited for that job philosophically, right? Maybe you have one child who, when it comes to these types of end-of-life decisions, just has a totally different opinion than you do. That might not be the right person to appoint, even though you might love everybody equally. You have to be practical also. So by doing those documents now, you can kind of have a say in the future if a point comes where you can't make decisions for yourself. Second, as I pointed out, it also makes life easier for your family. If something happened to me and all of a sudden I'm unable to take care of my affairs, I would hope to think that my family would kind of surround me and make sure that I'm getting proper care and be there for me and all those things. To kind of burden them by making them go to court on top of all those other things is not, really the best way to have to approach it. So, it can provide a lot of ease for the family by getting your documents in order, so that if the time ever comes, things are already in place and you don't have to go and get the court's involvement as to how to address these things. Also, I talk about here, and this is a big one for me. I mean, thankfully, I come from a family that's really close, and I see a lot of families that are close. I also see some that unfortunately are not. But when it comes to like family harmony, I think it can go a long way. Doing documents now, I think, can go a long way with preserving family harmony. So, I give the example, sometimes you go to court when families are bickering and they're bickering over silly stuff, which unfortunately I don't have the patience for. But that's my weakness as a lawyer. I can't fight over dishes for people. But I will say one of the things that does bother me is I've certainly been in some cases that unfortunately get a little bit messy, where let's say a parent, a mother or father becomes ill and they no longer can make decisions for themselves. And they have two kids, Jack and Jill. And Jack and Jill always got along very well. Jack and Jill are always very respectful to their parents. But let's say there's an issue that comes up, like Jack thinks that his mom should be able to stay in the community and live at home. Jill thinks that that's really not safe and that, mom really needs to go into a nursing home or some type of facility. So even though they're both very well-meaning, they just have a different idea as to what's in mom's best interest. And if mom never appointed one or the other to make those decisions, and she's no longer able to make those decisions herself, she's going to have to go to court for that. Or the kids are going to have to go to court for that. And you might have a situation, which again, I've unfortunately seen, where, you have two kids, they both think that they want to do the right thing. It's just a different right thing. And so, you get lawyers involved, and then all of a sudden, the kids start to get angry, again, for a good reason. So, which that is sad to watch. So I think, again, like in my case, by myself getting, putting what my wishes are down on paper, by saying which child I think is better suited to make this decision or that decision, I think that goes a long way to preventing that type of situation from arising. I kind of use the thing, look, my father, may he rest in peace. If he told the kids that he wanted a certain thing at the end of his life, whether we agreed with it or not, we were going to do it, right? It's our father, right? And so I think, that we're not the only family that are like that. So again, if someone can kind of, while they're healthy, express to their family what's important to them, and put in documents where people are able to make decisions for them, you again, hopefully can kind of preserve harmony in a family. And then lastly, it's just the practical aspect of the cost. For people to prepare documents, while not free, is certainly a heck of a lot cheaper than when people go to court. Attorneys or several attorneys get involved, and then it's really, a bottomless pit. So, it just doesn't make sense, quite frankly. Again, I know people don't like to think about these things. I don't either. I picked the wrong job, but that's what it is. And, as I often tell people when I'm preparing these documents for them, like a power of attorney, everyone's going to need a will, right? Unfortunately, everyone's going to pass away. But a powers of attorney and a medical directive, you do them now, but you might not need them, right? Hopefully, we all live a long life and we're able to make our own decisions because we're competent through, the end of our days. And then you might not even need these documents, but you still, have to be prudent about it. I use the example, I still have young kids. So my wife and I still have a lot of life insurance, right? Because our kids are gonna have to go to college, ostensibly, and all that stuff. Thank God every year it's been a waste of money. Right? So, and I think, you can make the same argument here. You have it in place because it's like insurance. So anyway, so that's the story as to why. What I'm really talking about are really, in most cases, there's like three fundamental documents that people need, really regardless of your age. And that would be an advanced medical directive, which I'll go through them all in detail, a power of attorney, and a last will and testament. So we can start off with the power of attorney. So the power of attorney is basically a document that I sign now that if I'm unable to take care of my financial affairs, I've appointed someone who has the authority to go to my bank, and the bank has to listen to them when they otherwise would not. So again, in my case, it's my wife. Something happens to me, I'm in a car accident, I'm recuperating in the hospital and going through a tough time. By having this document, she can go to PNC or Fulton or Somerset Savings, and the bank would have to speak with her as if it was me. But it's a lot more, there's a lot more than just that. You want to, when you do these documents, you want to try to make them as broad as possible, because the person that's helping you, you don't want to limit what they're able to do for you. So there's other authority that you would put in there. You would put in, or you could put in as much or a little as possible, but it often makes sense to kind of try to go pretty broad on it. What happens if I'm in the hospital and the insurance company is giving us a hard time as far as coverage. You know, if my wife just called up without a document, they tell her to go pound salt. But if she can present the power of attorney, they should talk to her on my behalf. Also, you know, if I need to pay taxes, if I have to continue and kind of close up my business, if that's something, sell a car, sell a house, really pretty much anything you can think of in the financial realm, you try to have some language in the document that would allow that person to help you. And again, much of the language for person A might very well be similar to person B, but there are certain things that, I ask each person individually, because some of these things are an individual decision. So for instance, and again, we'll kind of piggyback on this on the backside of things, but let's say, God forbid, my wife and I, we have our kids, and I need to go into a nursing home, right? So that's what we'll talk about. Unfortunately, that's a pretty expensive proposition, as many of you may know. So let's say my wife and I, we've worked really hard. We were hoping to be able to give the kids something, to kind of start their lives off with, or help with grandchildren, or whatever it might be. Sometimes there are some planning techniques that one can do to try to limit the financial burden that nursing homes create. It's very complicated. It's really not for an hour discussion. But bottom line is sometimes there are some things that you can do by giving assets away to children or reallocating them to the healthy first spouse. The important thing for this discussion to the power of attorney is, do I want to give my wife, in my example, the right to do that type of planning for me? Right? It's giving her a lot of authority, because she might be taking assets that I own and giving them to our children, or putting them in her name, whatever it might be. But it would be for the end game of trying to preserve some assets for the family, as opposed to having to spend everything, to care for me. So if I don't have that language in there, that specific language, she wouldn't be able to entertain that, and she would have to go to court to get that authority. But if I give her that authority now and something happens to me, she could then speak to an attorney like myself, or someone, like me, and say, my husband is in the nursing home. We've worked really hard to kind of build up this little bit of savings. Is there any way that we, first and foremost, I hope she says this, not jeopardize my husband's care, and still be able to, preserve some things for our family. And the lawyer will look at it and make a determination based upon the law at that time, and my health, and all those other things. So that can be really valuable. I mean, there are people that sometimes come to me who want to do that, and I didn't necessarily do the power of attorney before, and they'll say, Gary, my mom's had a stroke. She really can't speak or anything, but she gave me the power of attorney. And I'll look at it, and if the language isn't in there to do that, then we can't do that. And so I shouldn't say we can't do that. I would then have to, the fallback position was that I'd have to go and ask for a judge's permission to do that, which again, gets you into the whole idea of costing a lot more. A judge could say no, anyway, so that's part of that. As far as who you might name in your document, right? Who's what we call the agent? Who's the agent? Who, like in my case, my agent would be my wife. And then maybe as a fallback, maybe one of my children would be the alternate. So lots of times I might meet with somebody who's widowed and they have 3 children, and I'll say to them, who would you like to make financial decisions if you're unable to? And they'll say, I love all the kids. I want to put them all down, all that they should do it together. My typical response is, that's not such a great idea, because it's kind of going back to the whole thing, right? You could have 3 people who have to make decisions together, and again, it's one thing if they're acting like jerks and you don't really have much sympathy, but when you have people 3 kids who have different philosophies as to what's in mom's best interest, and they can't get their act together, mom is the one that suffers, right? So I tell people that this is not the way that these documents, and appointing people in these documents, is not the way to say, I love you, right? I mean, it really comes down to a practical decision. So in my case, I'm my mother's power of attorney because it's kind of my day job, right? I mean, she likes me much more than the others, but so that's why. And my brother's in the medical field, so I think he's like her healthcare agent. So there's that practical aspect of it. usually the kids would kind of keep each other involved, but you still need a point person. So, again, I think when it comes to choosing an agent, there's a number of factors. One, who kind of maybe has the best ability based upon maybe what they do for a living, logistics. Does one of them have 10 kids, 10 young children, and is running around all day trying to just take care of their own families? That's a factor too. Geographic aspect is another thing. So, you kind of usually when I meet with people, we kind of talk all these things through and try to figure out who might be, the best person for that role. You can always change it as, but at least at the time being, what's best. So that's the power of attorney. The other document that we talked about is the advanced medical directive. So just like the power of attorney, you're kind of making your wishes known and appointing people for financial decisions. What the advanced medical directive is really when it comes to like healthcare decisions. So, it could be, the typical thing is, if somebody's at the end of their life and all the doctors are basically saying that the chance of there being any real meaningful recovery is going to be tough, does one want to be kept alive through what they kind of call extraordinary means, and again, whatever people choose based upon their own personal feelings, by what they've seen in their own family, by their religious convictions, it's fine, right? I've done for more religions than I even knew about, and some people, some religions more than others have a lot to say on those types of things. Some do not, but that's just something I typically ask people, and many people just say that's not important to me, whatever. But the important thing is to get it down on paper. Because at some point, the goal is in a medical directive, you kind of lay out what your end of life wishes are as well as other wishes. And then the other part of the document is appointing somebody. So let's say I was appointing one of my sons to make healthcare decisions for me as my healthcare agent. Not an easy job, right? So, in some respects, I think the least that you owe a person that you would put into that position is some guidance as to what you want, right? It's if you have to kind of tell the staff that at a hospital that, just make my father comfortable, that's not an easy thing to say. It's a little bit easier if you know that you're really, there's no question that you're fulfilling the wishes of your father, right? So, so that's why you try to get these, those feelings down. Generally speaking, you can't get too specific, but generally kind of lay out what your feelings are on that. And then, when things come up, that child or that spouse or that friend or that niece or that nephew can, look at what I put down or what one put down as far as what's important to them, speak to the doctors and find out what, how that all meshes together, and then make a decision. I typically tell people that, even though I try to get pretty specific in documents and ask people, their feelings on these things, I tell them that doesn't even, that doesn't substitute for maybe having a 5-minute conversation with whoever you might appoint, because you can always discuss it easier in words when they can ask questions and things like that. Plus, it makes great Thanksgiving Day conversation. But other things, not just total end of life. If somebody's not doing well, do they want to live their last years at home? Are they okay if they spend their last years in a facility? Sometimes you don't have the choice, but if there are instances where you might have the choice, and so for people to be able to know that would be important. The other thing that goes into that is like HIPAA, right? We all have HIPAA, so part of a medical directive would kind of that whoever's serving would have HIPAA rights to be able to access your information. The typically when I'm doing these, just a little war story, but I also ask people. Some people, the family knows like when the time comes where somebody wants to be buried and what type of maybe religious service that they might want, but not everybody does. And remember when I was first starting out, I had a lady who never married. She, lived and she kind of kept to herself, but her neighbors would stop by as she got older and would have her over for the holidays and bring food over to her. And then she got sick and she was in a nursing home. So they called me up and said, can you just go meet with this woman? Which I did. She was lovely, but she was unfortunately end stage of having cancer. And I remember, again, not that I love to talk about it, but I thought it was important. I said, when the time comes, Susie, where do you have any strong feelings as to where you want to be buried? So she said, of course I do. I said, okay. She said, my whole family is buried. I think it was up in like St. Johnsbury, Vermont, which if you know Vermont, that's like,
Way up there.
yeah, that's like the rural part of Vermont, as opposed to the big city or whatever that is. But, and that there was a whole family plot up there. So, unfortunately, she did pass away a couple months later. And we got her there. You know what I mean? And quite frankly, trust me, I'm not the greatest guy in the world. But I mean, if I hadn't asked her that, I'm not sure if anybody else would have known because she was such a private person. So anyway, so that's the aspect of it with regards to basically the advanced medical directive.
Question.
Sure.
In New Jersey, there's also a poll form
There's a pulse form.
that my parents' medical team was adamant about what takes.
So what takes place, I mean, usually they are in sync. I haven't really seen one so pulse is basically, it's a relatively new, I think they came out about 5-10 years ago.
At least.
Yeah, but lawyers, it's usually more the relationship between a patient and their physician. And they fill out this pulse form, which is supposed to just be kind of other evidence, I guess, or directions as to what's important to a person as they come to their end of their life. It's usually much more brief, right? It's like a one-page document. But I haven't seen where there's a conflict. It might very well be the latter document, I would imagine. You know what I mean? If it ever got litigated, I would imagine the latter document subject to somebody's mindset when they were doing both those documents, you know what I mean? Could they appreciate things at both times? But usually they're in sync, right? So usually somebody who says that they don't want, that they just want pain relief and they don't want extraordinary treatment. Usually I've seen when it's been in both, but so that is the medical directive. And then the last document, like I said, is the last will and testament. So it's much different. Oh, and same thing, just real quick, but obviously, same feelings with regards to who you might name as your agent and your medical directive. To have a number of children or a number of family members is probably not a good thing. You really should have like one point person to make those decisions for you, because again, they have a differing opinion, you're going to be the one who suffers because no decisions are going to be made. I sometimes have put in language over the past few years where I might say, let's say somebody has 3 children and they want Susie, their oldest daughter, to be the decision maker. Sometimes I'll say, I'll put in like a little paragraph, Susie, while Susie is serving as my healthcare agent, for any significant healthcare decisions, I would request that she, speak to my other children prior to making such a decision. That being said, that should not diminish the ultimate authority that Susie has, right? So most times I think in most hopefully working families, kids will, no child really wants the burden of carrying that decision on their own anyway, so they would probably speak. But just to kind of add a little bit more emphasis, that this is what the parent wanted, I think is helpful. So with regards to the will, right, the will is different than the power of attorney because the power of attorney and medical directive are when you're alive. And when you die, they die with you. And while you're alive, a will doesn't really have much import either. When you die, obviously, it has a lot of import. So basically, what the will is it's your wishes on a document as to how you want your estate to be divided after you pass away. So first, somebody dies with $500,000. First, obviously, debts are going to be paid of whatever the estate, whether they're last medical debts or somebody had a credit card debt. Those are all obligations that have to be satisfied. And then after that, the will would then say who's to get what's left over. And not only who's going to get what's left over, but also how they're going to get left over, right? So if let's say somebody wanted to leave to children or grandchildren, and the grandchildren are, 15, they might not want those grandchildren to get that money outright, right? I have some people that don't want their children to get it until the children are 70. But, I guess it depends how you feel about the, wisdom of your children, but that can be important, right? So, sometimes in today's world, unfortunately, you have children that might have an alcohol issue or a drug issue. To give them a lot of money might be dangerous, right? But yet you don't want to not give them money to hopefully that they'll get through this part of their lives and then be more productive. So in a case like that, let's say somebody, again, I'll go back to my example, somebody has 2 kids, Jack and Jill. Jill is married, doing very well. Jack has been struggling along with, whether it's drugs or alcohol. And mom has $500,000. She might leave $250,000 of that money to Jill outright because Jill's shown that she's responsible. And with regards to Jack, she might put Jack's monies in trust, right? So that basically means that Jack can't access it to go to the liquor store or, to, God forbid, buy drugs or something, but the money's there to help him, right? So that would be somebody who asked about a trust, right? So there are different types, there's thousands of different types of trust. This would be one type of trust where the money's being held for Jack. There's $250,000 that's there for him, but he can't go get it, right? There's a trustee, and the trustee is really the kind of the gatekeeper who's going to watch those monies. So if, let's say, Jack came to the gatekeeper and said, you know what, there's a really good rehab program that I found out about that's in town, and it's $3,000. Can the trust pay for it? I would think that the trustee would say that's a good use of the money. If Jack came and said, you know what, I'm having a bunch of the guys over to watch the game and I want to get 3 kegs of beer, I would like to think that the trustee would say that that's really not what this is about. So that kind of just goes to the general point of, again, not that a will states not just who you leave to, but also how you leave, which can be equally important. Another time where that really comes out to be important is, let's say somebody has a disabled child, and a lot of governmental benefits that might help that disabled child are based upon means and having monies. So, if somebody has a child that's had special education, is pretty significantly autistic or Down syndrome or whatever it might be, that child might be getting Medicaid, that child might be getting Social Security. And the reason why they're getting it is because that child has very limited assets. Sometimes, if that child then got an inheritance in their name of $250,000, that's nice, but A, they probably can't manage it, right? Because of their disability. And 2, having that money in their name now is going to knock them out off of all these governmental programs that are really helping them. So there are some ways to put monies in what they kind of call a special needs trust, where that money is for that disabled child, but it doesn't count as theirs, so that they're able to maintain their benefits. So again, I'm just kind of using those as kind of broad examples as to, putting together a will. Again, you have to kind of analyze, not who you might want to give to or what, whether it's a church, whether it's, the United Way or some other type of charity, but also how you might want to leave to them. With regards to, I kind of referenced here fiduciaries, right? So we talked about having somebody as an agent and a power of attorney and an agent as a medical directive. What's it here? Sure. Whatever you want. You also have fiduciaries in a will, and those fiduciaries are generally called executors. So executors are the ones who basically kind of control your estate and wrap up your affairs after you pass away. So, where I was telling you earlier, I'm kind of finicky about having 2 agents named as a power of attorney or as a healthcare agent. I'm a little bit less, personally, a little bit less rigid when it comes to having executors in a will. So back to Jack and Jill again, I mean, if mom died and she wanted Jack and Jill to be co-executors, personally, I mean, again, I'd want to find out a little bit more just to make sure they can get the job done, but I'm a little bit less concerned on that because mom isn't here anymore, right? So mom's well-being or best interests aren't really at issue. if Jack and Jill can't get their act together, they're probably just harming themselves, right? But they're not going to, at that point, really harm mom's interest. So, but the executors are the ones who take care of that. I also mentioned the trust. If there was a trust, that person who I talked about as being the gatekeeper, that would be the trustee. That's another term. If young couples are coming in, then they also want to name a guardian if they have minor children, or if they are hoping to have minor children, in case God forbid something happens to them, who's going to raise their children. All these pleasant things. So anyway, that's that. I don't know if any of you have heard of, yes.
I have a question. Okay, just going back to power of attorney. About a year and a half ago, my husband was diagnosed with cancer. Okay, so he knew that they were it's advanced stage 4. Okay, so the thing is, he had a bunch of brokerage accounts. So we went to each one, and each one had a separate form for power of attorney. Does that mean that, things like for the bank and all, because we have like his, hers, and our banking accounts? Does
Right.
that mean that I don't have power of attorney over that?
You
or
probably don't. I mean, if you have a joint account, you might
Yeah.
have rights to write on it as a joint owner.
Right.
But if you did one, let's say Merrill Lynch gave you a power of attorney, your husband a power of attorney, and you sign that one, most likely it just applies to those assets in Merrill Lynch.
Okay, because they had us sitting in the office and they were witnessing us.
Yeah,
so-
yeah, that stands right.
So then, he's in the hospital now, so I should go and check these.
You
It's almost time to do taxes, so, and he always did it with our daughter. okay?
Yeah,
So I should find out.
you
What
probably should see
other-
the scope of it, right? Because it might just be, I mean, there's, power of attorney, I should have said this earlier, but it's a very general term, right? It's like saying, I have a vehicle. Well, do you have a bicycle or do you have a Rolls Royce, right? I mean, a power of attorney, I could give a power of attorney that basically says, I give my wife the right to sell my glasses. It's power of attorney, but all she can do with it is sell my glasses, right? As opposed to what I talked about earlier, kind of having a global one that if my wife needed really to step in for me, she could do pretty much anything we think of, which would be going to the bank, going to a brokerage account, you know what I mean, all that stuff. So I would look at what you signed, and if it just kind of deals with those specific institutions, it might be when he's, quickly building up to it, have him maybe sign one that's more global.
I should do it right away. I mean, I
Okay.
know, we
Yeah.
sat in the office
Yeah.
and the person saw it and filed it, but this is like over a year ago,
Yeah,
but there's nothing that's been recent.
well, I mean, they should last forever. I mean, they shouldn't have a shelf life, really,
Yeah,
generally,
but
although
is there
somebody.
a general one that,
Yeah, there would be, sure, there's like the general, there should be, I mean, there are general ones that are kind of all encompassing, hopefully.
well, they recently gave him that pulse form, that they were talking about, he refused to sign it, he said, well, I got my health directive. But then we have some stuff with private sent us a form about billing and stuff like that, when there's alternate agents and stuff, and he didn't sign that either.
Mhm.
So I'm wondering,
You might not want, I mean, look, anyone, that people can do what they, or do or not do what they want to do, you know what I mean? So, but again, I mean, generally speaking, it's kind of good to have all the stuff to have a broad-based documents. I stopped on Thursday, I stopped to visit a friend of mine from college's mother, she's 90 years old. She told me she'll get back when I'm trying to tell her to sign documents, she said so when she's ready.
so. We have different credit cards too, we have 2 different banks, because I used to work for different
Great,
companies.
yes,
So does that mean I have to go to
I would talk to them,
the bank and ask them for?
I mean, it's a very, yeah,
Is there a general form that would say this includes? the
it
bank?
should be, yeah.
Where would
Yeah,
I?
I mean, probably a lawyer, I mean, you might be able to find things online too, but I mean, just trying to like a general durable power of attorney would be a good thing.
Okay.
So, actually just, my friend's mother, who is so reticent to sign these things, one of the things I brought up, I can tell you, right, so there's a couple different types of powers of attorney, like the one I signed, right, I signed it on Monday. And technically, my wife had authority for me on Monday, even though I was still kind of able to take care of things. Because I know that she's not going to abuse it. Some people, they're just very skeptical, or they're just so hesitant to give up any type of control. There is another one that's kind of called a springing power of attorney. And a springing power of attorney is, let's say I signed it Monday for my wife. She can't utilize it. It doesn't take effect until it's what we call, that's why it has the name springing, until something springs it into effect. So typically what springs it into effect is if two doctors were to opine that I can't make decisions for myself anymore. So if I signed it today, again, my wife couldn't use it today, but let's say, I was in a car accident, I was in a coma, while I was in the hospital, she could get two doctors basically to say that, Gary can't make decisions for himself anymore. And, attach those opinions to the document, and then it should be honored at that point. I'm not a big fan of those generally because, although I tried to give that as a kind of a hybrid, for my friend's mother, because maybe I thought maybe at least she'd be willing to do that. But, the reason why I'm not such a big fan is look, if you don't trust the person, or if you're not giving him power because you don't trust the person, then it's really a question that you don't have the right person, right? Not when it's going to go into effect. And again, I suppose I could think of a fact pattern where, maybe the person really needs help, but the doctors don't sign off, and then, you kind of stop, you're not really helping it. So, but it is an option. The real quick on taxes, I kind of laid out the taxes used to be much more of, estate taxes used to be much more of a concern in New Jersey. We used to have a very low threshold. Estates that were more than $675,000, which in New Jersey, you own a house and maybe you have a savings account, that you bought your house a long time ago, you're going to reach that limit. So, which was always crazy to me. But back in several years ago, there was a whole, they fought it out down in Trenton, and they got rid of. So right now we don't have an estate tax in New Jersey. Right? Yeah, for now. All right. And since we spend money so consciously here, I don't know. I'm just kidding. Who knows what the future brings, though, right? I don't know. Federally, the federal limit is very high right now too. It's if somebody has an estate that's just under 13 million. It's not subject to an estate tax. However, that law is due to sunset. And again, for better or for worse, it doesn't affect most people, present company included, but it's supposed to sunset to go down in 2025 to just under 5.5 million, which again is a lot. The more important thing though is that's going to give it time for Congress to kind of negotiate it. So they could bring it down lower. Who knows what they'll do? But that's where we are on that. We do have in New Jersey, we have what they call an inheritance tax. So an inheritance tax is not based so much on how you have, it's based upon who you leave it to, which I always thought was kind of unfair, but if you think of your family as a tree, you have your parents, then here's you, then you have your children, your grandchildren. If you leave to any people on that tree, if you leave to your parents, you leave to your children, you leave to your grandchildren, you leave to your great-grandchildren, they are not subject to an inheritance tax. If I left monies to my brother, it would be subject to an inheritance tax because he's outside. First of all, he beat me up when I was younger, no. But because he's not, on that tree, so to speak, with my family, it could be subject, and it goes like, depending upon, they break those relationships into different classes. So my brother would be a different class than like if I gave things to my old high school buddies or whatever. But it's usually around 15, 16, 17% as the inheritance tax. So again, not every state has it. I don't really understand why it's quite frankly constitutional, but nobody asked me. It just doesn't seem right. So anyway, that's how taxes generally work. I pointed out here, what happens if you don't plan for your tomorrows, and I kind of touched on it earlier, but that is basically where a couple things come up. One, if something happened to me, just to reiterate, and I didn't have my documents in place, then my wife would have to go and institute a guardianship down in Somerville for me, which again is not ideal. There's another thing in New Jersey that isn't utilized as much. It's called a conservatorship. So with a guardianship, it's when I'm incapacitated. A conservatorship is when, if I was not incapacitated, I technically could do a power of attorney, but I elect to do this conservatorship through the court anyway. So it has very limited usage, at least, in the past, but put it this way, sometimes like people in town or, in the area, they might have come to me and they say, they just really are very private people. They don't have families. They really don't have friends. They keep to themselves. And like, sometimes they'll say to me, or I'll ask them, if something were to happen to you, who's going to take care of your finances and all those things? And I just met them 10 minutes ago and they'll point to me, like they want me to do it, right? So, I'm generally hesitant to do that because anyway. But I mean, if I were to do that, then typically what I would tell them, I'll help you, but I want to set this up with the court and have a conservatorship, which basically would give me all the rights to do things for them, but I'm being watched, right? Which is what they want, I would think, and what I want too, because I don't want these, family members who never really cared about this person or never even knew about them. And now all of a sudden they know that they might get monies after the person died. I don't want them to say, hey, what guarantee with all the money? So with this type of conservatorship, I'm helping them, but I'm also reporting to the court on a periodic basis. So like on an annual basis, I might say, write to the judge and say, Judge, this year we started with this amount, this is what came in, this is what went out, and this is where we are at the end of the year. And they'll, the court will then bless that year, and then the next year and the next year. And then when the person ultimately passes away, if somebody tries to call me out for something, I can just say, look, we have orders, so go, do what you want, right? But it's I think it's generally that to me is one of the limited reasons why somebody might have this conservatorship. Another thing is that I kind of reference here is intestacy. So what's intestacy? Intestacy is what happens when somebody passes away without a will. There's a whole bunch of statutes that basically say, Bill died with $1 million, never married, no kids. Where does this $1 million go? Because he never did a will. And, where it would go would depend upon Bill's family situation. I mean, if Bill was married, or Bill was not married but had children, that would be a different scenario. If Bill was married for the second time but had children from the first marriage, that's another, rule. If Bill never married, never had children, then did he have siblings? It kind of just spans out. It's not ideal, right? Because sometimes people end up leaving money to people that they really didn't like, right? Or didn't even know, right? Didn't know family members. Again, not a war story, but I had a fellow who passed away, didn't have a will. The court asked me to kind of, get him buried and wrap up his affairs. He had probably a couple $1 million at least. I found out he had like an estranged brother in China.
Wow.
My Mandarin isn't what it used to be, but I ended up writing letters to the guy and then saying, look, you're going to be entitled to this $2 million, whatever it was. So it took me forever. It took me like a year or two to get the guy to respond. I would think most people would jump, but I guess he thought like I was like one of those snake oil, I get those little faxes too that, I had some great uncle who just died of COVID with $400 million, and I'm the sole beneficiary. I haven't seen it yet, but whatever. But again, I don't think these people had a close relationship. I remember I had another one where a fellow was, spent his whole life in an orphanage, never really had any family, and usually when that happens, if I'm involved, I hire a genealogist, assuming that there's sufficient assets. And that genealogist goes and does a whole, and at the end of the day, and sometimes takes a couple of years to do this because you have to go to vital statistics and the health departments all over the world sometimes. But at the end of the day, they'll usually give me back a report saying who might be entitled to the proceeds from this estate. But with this one fellow who was in New York, we never found anyone. And I think again, this is going on a long time ago. At the end of the day, I had to write a check to the state of New Jersey. which, I mean, I'm a proud Jersey guy myself, but I mean, not that proud. So, and technically, just so you know, I mean, New Jersey actually holds on to it in perpetuity. It's not like they're supposed to, I think they borrow against it and all that stuff, but they're not supposed to kind of take it as their own, although. Right. So, but yeah, right. But sometimes it bothers me because the guy was apparently very close to this orphanage. And if he'd just written down something on a napkin, I would have had an argument to go to court and say, give it to this orphanage. So that's, look, I mean, all this stuff obviously just goes to the importance of trying to get things down in writing and, so that's that aspect of it. Real quick, I guess we can just kind of talk about long-term care, just to kind of touch base on that. So long-term care is unfortunately an expensive thing and an important thing that a lot of people want to talk about because right now, if somebody goes into a nursing home, you could easily be looking at $175,000 a year in nursing home costs. Right now, we're in Central Jersey. I mean, $15,000 a month is not shocking. I mean, it is shocking, but it's not unusual, unfortunately. And so, it's not, it's common that people call up and say, look, my husband, my wife, my parent is going into a nursing home. Is there anything we can do? Usually, especially if it's the spouse, right? Because the spouse, obviously, I mean, they're concerned obviously for their ill spouse, but they're also concerned about their financial stability going forward because it is such a heavy burden. Real quick on it, I mean, when people go into a nursing home, I mean, put it this way, if somebody breaks a hip, right, and then they go to the hospital after surgery, then they're usually after the surgery, they're going to be discharged to a facility for rehab. And when people are going through that rehab process, that's usually covered for by Medicare, which most people have, right? Because Medicare doesn't matter on how much you have. Bill Gates is going to have Medicare, Warren Buffett has Medicare. It's not what they call means tested. It's not based upon how much money you have. Medicaid is. So if somebody goes to a facility to rehab after they've had their hip surgery, they're going to stay there for whatever it might be, a month, 2 months. At some point, they're going to terminate that Medicare when they feel like that person has plateaued. And hopefully they plateaued where they can get back into the community and have a meaningful time there. But, once it terminates, there's a decision that often needs to be made. Can the person go safely home back to the community? Or do they need to stay in that facility or another similar facility? And if they stay in that facility, then Medicare will no longer pay because again, Medicare will no longer pay because Medicare really only pays when you're having like a procedure or when you're in a facility to try to get better from the procedure. Once you've kind of stabilized, then you're kind of what they call a custodial resident. You're not there because they're getting you better. It's just that this is the kind of care that you need to kind of get by safely in life. So once you kind of are determined to be there for custodial reasons, that's when Medicare would no longer pay, and people who stay in those facilities are either going to get paid for that either by long-term care insurance, which most people don't have, but some people do, or people will privately pay if they are able to, and sometimes they will for a while. And then the third way is through Medicaid. But Medicaid, like I said, unlike Medicare, is based upon generally being poor. So if I was a single guy, and I went in, and let's say I had $200,000 of assets. Poor for me as a single person would be having less than $2,000. Poor. So if I went in, I mean, without doing anything further, I would spend down my $200,000, and then as I was getting close to that 2,000, I would apply to New Jersey and say, hey, I'm the guy that you now have to pay for because I can't live at home in the community anymore. I don't have any more money. And, they would review my application and hopefully they would approve it so that, maybe in December, I spent my last payment and now I'm under 2,000. And then January, hopefully then New Jersey would pick up for the rest of my life. So, but again, that's a big expense. And so we're talking about, really it could be assisted livings too. So it's a little bit different if you're married. It's not great either. But if I was going into a nursing home, and let's say my wife and I had owned our home and we had $300,000, they wouldn't make us both it's not great either, don't get excited. But in that case, what they would generally say is, okay, wife, you can stay, we're not going to take the house away, the house can stay in your name, or you can stay in the house, we're not kicking you out, we're not going to force you to sell it, although we'll talk more about that. And of this $300,000 of liquid assets, whether they're in my name, whether they're in my wife's name, or whether they're in joint name, what they basically would say in a situation like that is they would allow her to keep something. Usually there's a ceiling of it of like 130,000. And then everything else they would say has to get spent down. So the 300, 130, my wife could keep. The other 170, unless any other planning is done, would have to get spent down. And then I would go on Medicaid. It's not so great, but that's kind of the rules. And that's why sometimes there are some techniques to try to give my wife a little bit more than she would, but that's, not what the state's going to tell you. But real quick, so when you go to apply, when I went to apply for Medicaid, part of the application is, I don't know if anyone ever heard, they have what they call a 5-year look back, right? And so what they're looking for during that 5 years is, let's say again, I'm a single guy. Don't tell my wife, I don't really want to be a single guy. It just helps with the hypo. But let's say I'm not feeling so well. I have $1 million and I have 4 sons, right? So not feeling so well. So today I give 200, I want to help them out in the future. So I write checks to each one of them for $250,000. And I was right. 4 years after I wrote those, I was right. I wasn't feeling so well. I have to go into a nursing home. I couldn't. So, and I go to the state and I say, hey, I'm the guy you paid for. I can't live at home anymore and I don't have any money. Well, they're going to look and they're going to see that I gave away within that 5-year look back $1 million. And they're going to say, sorry, Gary, we'd love to help you, but because you gave this away, you're ineligible.
Wow.
Right. And then
For 5 years or forever?
it could be not forever. There's like a calculation. There's like a calculation which they try to determine what we call the period of ineligibility. So anyway, I mean, look, if I thought about it just as a hindsight, what I would have probably done, I would have talked to my kids and said, you know what, I made it 4 years, right? I want to protect this monies for you. I would say, give me, or you guys pay on my behalf, pay that last year, right? And then 5 years and a month afterwards, I would apply if I was able to kind of articulate this, right? And then they'll say, hey, did Gary, did you give anything away within the past 5 years? I can honestly say no, because it was 5 years and a month earlier. But anyway, it's a nasty program. It's not pleasant to, unfortunately, to kind of have to go through, especially, when at the time that people have to do that. So that's the look back period. One thing, that's important to know. So we talked about when I go back to my discussion with my wife and I, and I told you that she could stay in the house, right? But it doesn't just end there because, like most people, my wife and I own our home jointly, right? So let's say, actually, you'll see why, but let's say I have another wife. Husband one is enough, but if let's say this other wife and I own our home jointly, and I go into a nursing home, and I've gotten to the point that the government's now paying for me. But let's say my other wife dies before me, right? So now I own that house, right? Because we owned it jointly. Get it? And then what Medicaid is going to say in that circumstance is, hey, Gary, you're never going back home. So we expect you to sell that house, get whatever money, because now you own it by yourself. That's why I have a second wife, because I didn't want to knock off one I love. So, and then they would say, use that money from the proceeds from the sale on your care, and then when you tap out of that, come back and talk to us again, maybe we'll put that on it. So if that were the situation, we had time to plan, you know, what I might say at that point, or, you know, if we met with somebody, they might say, you know, Gary's going into the nursing home, you guys own this home jointly. Let's get the house out of Gary's name and just put it into the wife's name, okay? Which, again, is not a problem for the 5-year look back, because they don't care about interspousal transfers, because when we go to apply, they're looking at us as one entity. So whether my wife and I have $1 million in my name, in her name, or in both of our names, they see that situation as the same. They see us as one unit. So because of that, they don't penalize you for transfers that might be made between a husband and a wife. But in that case, if we were able to, and again, knowing that we have children that we'd like to leave something for, if my wife knew that I was in a nursing home, we were able to get the house into her name. And then let's say she has a will, an old will that we leave, sweetheart wills we leave to each other, right? That no longer is so practical, because if she dies first, why does she want to leave me everything that's just gonna then have to get spent at the nursing home? So at the time that my wife puts the house in her name, she might very well want to do a new will where she might leave me something, because in New Jersey, you can't, generally speaking, disinherit a spouse. But you don't have to leave them everything either. It gets complicated, but let's say that you have to leave your spouse at least a third under New Jersey law. So in that case, you know, my wife would have the house in her name. She would then do a new will where she leaves me whatever New Jersey says she has to leave me, but then she leaves everything else to our kids, right? So instead of using all the proceeds, potentially having them sucked up by the nursing home, you know, they'll get a lot, but hopefully our kids will get something too, which is, you know, going to be important to us. That makes sense? Okay. Yeah.
Okay, I mean, you talked about the sexual stuff, but it just came out recently. My husband obviously had a will, okay, but we turned out we had another grandchild, my last Christmas. So, and we also had a child who got married. All right, my husband had bought a co-op in Manhattan, and she was living there because she worked in the city. Okay, now she's married and lives in a different state. Okay, so he never wrote it down that, you know, the assumption was she was going to inherit that co-op, right? But her job took her elsewhere. Okay, so now it comes out that since my name is not on it, that I'm going to inherit this co-op.
Yep.
Right? So what should I do? I mean, it's now supposed to be in his will. He should revise it.
Well, I mean, it might, if it's not specifically bequest, you know, sometimes you have like what they call specific requests. Like you might, like I might say, I want to leave everything to my wife. That's like a general request, but let's say I specifically want my son to have my car, right? So if it wasn't specifically bequested, the condo, then I assume it would probably just fall under that provision that says where everything else is supposed to go, if it's not otherwise detailed. So, I mean,
well, he was going to try to sell it, but
Well,
the market's been kind of really crazy.
yeah, I mean, if he sells it, then it's cash, right? Then it's no longer a
Yeah,
problem.
Well, he's now got a tenant.
Oh, well,
You know, this just happened within like 4 weeks.
Yeah.
And so all of a sudden got really complicated.
I mean, look, you also have an issue, again, depending upon how it's actually owned, is sometimes when you have properties in other states, you know, it also, sometimes you have to have what we call the probate process is basically how you tidy things up, but,
Okay.
Yeah.
You have to take it.
you might have to, it depends on it.
You have to avoid it, you know.
Yeah, it's not
Make
so,
it very clean.
yeah, it's not so bad in New Jersey. Yeah.
But going back to the power of attorney for the financial stuff.
Yeah.
Does that mean, since he's in the hospital, do I have to now bring the other, let's say, go to one of those other brokerage houses and say, can we have a power of attorney, or? we
You
have
might want
find a
to.
whole
You might want to. Let me just finish up real quick. I don't want to keep it. Anyway, I think that we hit our time. So, anyway, if anyone has any questions, I'm happy to help out. and art stay around too, so.
So where is the best place to store the original copy of your will? I've heard safe deposit box, I've heard definitely not safe deposit box.
Yeah, I'm not a fan of the safe deposit box generally, because sometimes it creates difficulties for the person to get it. Like mine, I actually have like a fireproof safe that I just kind of keep in the house. I'm not really that concerned about people stealing it. It doesn't really have much. But if there's a fire, I guess it would be nice. So I mean, I think, to me, like all these documents, it's helpful to kind of keep them in the house and let whoever you named, let them know where they are, because if God forbid there's a crisis and they need to access to your house to get the original, they know where to go. Yeah. Good? No, yes.
Just a quick, what's a revocable living
Yeah, I
trust?
should. So a revocable living trust is kind of it's like an alternative to a will. And basically, so as I was just touching on, the process when you die and closing up your affairs, that's called probate, right? And you basically have to go down to the surrogate's office in Somerville. Probate in a lot of states is a bad word, because the probate process in a lot of states is really could be burdensome. You know, because I typically say, and again, I'm a Jersey guy, we don't do much right here from a bureaucratic standpoint, but our probate process, from all I've seen and what I've been told, is probably the most streamlined of any other state. So it's really not, I mean, if families are fighting, that's gonna be a little bit different, but that would be different, that would be whether you have a trust or whether you have a will. So because in some states, the probate process is a pain in the neck, they try to figure a workaround. And the revocable living trust is really that way, because what the trust is basically you put all your assets into this trust. You have the rights to them during your lifetime, but when you die, the trust itself says how things are to get distributed. So you don't necessarily have to go to probate, because the trust talks on its own. There are, I mean, if you look at the paper on any given day, someone's giving you a free lunch to talk about revocable living trusts and, you know, at some hotel. I've done a lot of wills, obviously, over the years. I've done few revocable living trusts just because I don't necessarily see the benefit generally. You know, the only time I really would think that they're of any type of benefit is, you know, let's say you have somebody who has property lives in New Jersey, but owns property in Florida. You know, if it's not a trust, then they're gonna have to do their probate in New Jersey, but to convey that house, they're gonna have to open up what they call an ancillary probate down in Florida, which could be more troublesome than it's worth. So in that case, maybe it would make some sense, because then with that family, you could put all of the properties, including the Florida property, into this trust. And thereby they wouldn't have to do a probate down in Florida at some point. But other than that, I mean, again, people promote them a lot here, but the bang for the buck, so to speak, is not nearly as great as like maybe if you were in another state. So, yes.
My mom passed away, we co-owned our house, we ended up having to pay inheritance and transfer tax, but, now, like the tax bill and a lot of the bills are coming to us to the estate of my mother, and then my husband and myself, right now, you know, she wanted to have a house. Is that ever gonna go away, or do I have to just? The township is billing the estate of.
Right, but that's it. So who's the rightful owner now?
My husband and me.
Not the estate. The estate conveyed it, right?
Yes. He left
So
a
how
year
long ago?
It was a year ago.
So sometimes it takes a while for, right, because you file the deed with the county,
Right,
and the tax bills get distributed by the municipality.
and, yeah.
And sometimes it doesn't, believe it or not, sometimes government doesn't work so quickly.
Oh,
So it might be a function of that, because if you're the title owner, you know, I mean, as long as you're paying the taxes, right? No one's gonna attack you. But it might just kind of be that abyss. I mean, I'm not sure